Our next panel is on financial firms in the SEC's crosshairs, referring to asset managers, broker-dealers, private funds, hedge funds. We have a great panel, and I want to first introduce our moderator, Peter Altman. He's a partner at Akin Gump, or I guess just Akin now, Akin, who also previously served in the SEC Enforcement Division in LA, as well as a member of the Market Abuse Unit. His practice focuses on representing the investment management firms and investment advisors who are facing so many issues in this area now, and really appreciate you being here, Peter, and welcome. I want to introduce Hardy Callcott, a partner at Sidley Austin in San Francisco. Hardy was previously general counsel of Charles Schwab, as well as assistant general counsel for the SEC's Market Reg Division, and his practice focuses on enforcement, defense, and regulatory counseling for the financial services industry. Welcome, Hardy. Beth Dallmeyer is an associate director at BRG, or Berkeley Research Group, in Washington, D.C. She's a CPA with expertise including financial services litigation and forensic investigations, financial statement analysis, and compliance. Welcome, Beth.
Thank you.
From the SEC, formerly from the SEC.
No, what do you mean formerly?
No, I was actually going to do Jason. I wasn't doing you yet.
All right.
You're out of order on my list. Senior Managing Director and Chief Legal and Compliance Officer at Lido Advisors in Los Angeles. At Lido, Jason is responsible for the firm's legal and regulatory functions, and he previously served for over 7 years as an attorney in the SEC's Division of Enforcement, where he was a member of the Financial Reporting and Audit Group. Welcome, Jason.
Thank you.
And now currently serving at the SEC for over 18 years in the San Francisco office, where he's an assistant regional director and a member of the asset management unit. We have Jeremy Pendrey. Welcome, Jeremy.
Thank you.
Peter, let me turn to you.
All right. Thanks a lot, Bruce. Great to be back here, as always, for this great conference. So let's jump right into it. We have a terrific collection of panelists to go through this interesting panel. So first topic, discussion of some trends in the regulated entity space. And it seems like every conference I've been to over the last 6 months, today included, a huge topic of conversation has been electronic communication use by individuals at broker-dealers and investment advisors. We're not going to go too deeply into that topic, as it's already been touched upon in depth today. But it does raise, I think, an interesting issue, which was actually raised in the last panel. As we wait to see what's coming out of the sweep currently underway involving some of the largest asset managers out there, it does seem that the industry, at least to my eye, is facing an SEC that's increasingly focused on non-scienter-based violations, which was certainly a hallmark of the Mary Jo White era SEC that I worked at. I've also experienced quite a increase in referrals from examinations to enforcement, which is not something that any RAA, at least on the investment management side, wants to deal with. And it's really actually become noticeably more common. So I wanted to start with Jeremy. The SEC will get the first word and then probably also the last word on this panel. The Division of Examinations annual report for 2023 cited enforcement actions that flowed out of a number of what I think of as strict liability-based violations. And so you would have custody rule was cited, Reg BI was cited. Am I right that referrals have ticked up in some meaningful way? And is enforcement, including the asset management unit that you're in, more focused on bringing technical violation cases, like things involving the custody rule, or maybe even soon enough, the marketing rule, which I think that might be the first time that is referenced today. Jeremy?
Yeah, so look, the Division of Examinations has always been a critical source for us in identifying problematic conduct. It's been very important to the AMU. But I can tell you from my perspective, nothing has really changed in the referrals that we are getting. So is the Division of Examinations a strong source for our cases? Yes, but that's nothing new. And keep in mind that a very small percentage of exams lead to referrals, and then an even smaller percentage of those referrals lead to cases. So it's hard to correlate, for example, the number of exams happening in a year, or even the number of referrals from exam happening in a year with cases that end up being enforcement cases. There really is just a lot that happens between one and the other. So that I don't think that there's a, in my view, I haven't seen anything change essentially. Of course, I can't comment on non-public numbers, things that are, as far as the number of referrals, which again is not something that is visible to the public, so I won't comment on that. Are we focused on bringing cases that are more what you're calling technical violations? Well, let me first talk about the custody rule. Absolutely, the custody rule is something that's important to the division and to the asset management unit. In the advisor space, proper custody of assets is critical. In September 2022, there was a large group of cases filed where private fund advisors had failed to perform audits or deliver audited financial statements, and that was an important message to package those cases together and put them out at one time. But in my view, that's neither new nor technical. And we have brought custody rule cases in the past. In my group in San Francisco in 2017, we brought a case called Columbia River Advisors that's a custody rule violation. And I think if you were to ask investors whether they think the custody rule is a technical rule, if you were investing your money or your institution's money in a private fund, you'd want to make absolutely sure that custody of assets is done properly. And even though there may be technical aspects to the rule, that doesn't mean that violations don't create real risk to safety of client assets. So from my perspective, it's an important rule, even if it does have technical components. And lastly, I'll just comment on the marketing rule briefly, which basically to say that it's just underway, and I don't think we know yet what the enforcement picture will look like. Of course, it's part of our mandate to enforce the rule, but that remains to be seen.
Well, I was at a conference recently where someone from examinations noted that they had seen something like 50 deficiency letters from exams relating to the marketing rule, which I found notable. And certainly from our seat, I think we're hoping to see some consistency with respect to the way exam approaches that, maybe even some further guidance in the form of a risk alert or the like. Jason, from your seat, way down there,
right next to the SEC.
Yes, yes. Is the current approach of SEC enforcement affecting the way you think about risk management from an in-house lawyer and compliance perspective?
Yeah, no, absolutely. Coming from LA, I think there is no more anticipated day than when the enforcement results come in for a fiscal year and when the division exams promulgates their priorities. And when I think about the seat that I'm in and others similarly situated, it's those two sources that really inform and chart the course for any RIA in particular. I mean, the concepts of regulating an investment advisor is very much principle-based as opposed to a broker-dealer, which Hardy, I think, is going to get a lot more into. And those two sources allow us to take what is regularly done from a risk perspective and then deploy our resources, which are generally already scarce, into areas that we think either the exam staff or the enforcement division will be interested in. So we have this overlay of the fiduciary duty and everything that we do in compliance to identifying the conflicts, disclosing those conflicts, and molding the appropriate policies and procedures to address that and our faithful exercise of the fiduciary duty. But also now with what I view to be an increased scrutiny with the technical, as you put it, Peter, rules, custody, and the rollout of significant rulemaking. We just digested the 100 or so or more pages of the new marketing rule, and being able to implement those requirements for this year was a significant undertaking. On top of that, now we have proposed rules relating to Form PF and other types of requirements that are going to impact the everyday business of a investment advisor. So to answer your question, yes, absolutely, it does very much inform the way we and I think others in my seat think about the next year and coming years.
So That's great perspective, Jason. Thank you. So Hardy, from outside counsel perspective, two-part question for you. Has the current climate affected the way you, for example, might counsel a client who is preparing a response to an exam deficiency letter? Maybe how thorough the response is, how much remedial or action is going to be taken in response to the cited findings? And then also, another kind of a related question, how has the current environment affected how you advise clients on self-reporting? We've heard an awful lot of the cooperation discussion today. What do you think about self-reporting?
Yeah, so let me start off by saying, there used to be a world where there were exams and then there was a deficiency letter and you got to respond to the deficiency letter and then there was a decision to refer or not to enforcement. I think that process has collapsed in a lot of cases. I think the referrals happen a lot earlier in many cases. And so a lot of our clients during the exam process, where they used to handle a lot of exams in-house, they bring us into the exam process earlier because they think there is somebody from enforcement who is either explicitly there, part of the exam, or is sort of in the background monitoring the exam for a possible quick enforcement action. So I think clients have been bringing us in earlier, and I think they're right to do so. Obviously, there's some exams like a new advisor that's within their first year of filing with the SEC. That's probably not going to be an enforcement kind of matter. But we're seeing a lot of sweep exams where our perception is that enforcement is at least in the background looking for the example cases that they can bring, and so you have to treat the exam a little bit more like part of the enforcement process than would have been the case 10 or 15 years ago.
So does that include like more thorough written responses during the exam, treating that deficiency letter response as like, this is your shot to get your statement out there, because if you mishandle it, you might be talking to someone down the hall.
So that's absolutely right. I will say, though, that I think there is an opportunity sometimes, increasingly, we get requests from the exam staff to do remediations for customers, and that's a number that the exam staff tracks in their annual reports. And so there is an opportunity there to, it's not exactly self-reporting, but an opportunity to do something more proactive and remediate in the exam with the hope, although not for sure, but I think there is an opportunity there to make it a less attractive case for enforcement after the exam is over.
Got it. What about just sort of proactive self-reporting these days? Is that something that you might weigh more heavily in favor of?
Every single person from the SEC has said, self-report, you got to come and self-report. I have to say, I look at the cases and I don't see a lot of credit for self-reporting. There are areas, cybersecurity is a good example. If you're going to have to do mandatory reports to states, you might as well go and self-report to the SEC as well, even though there's not a current rule that requires that. So there are times when you do it, but I have to say, on electronic communications, I probably talked to a dozen firms that had not been included in the sweep, and not a single one of them ultimately self-reported.
Well, we're going to try to stay away from e-coms on this panel. So Beth, we mentioned the marketing rule in passing, and as I said, the industry is hearing about a lot of deficiency letters coming out of exams relating to this new rule. What has been your sort of angle of intersection in this area?
Sure. Well, as Jeremy mentioned, it's unclear, it's early, but there's a lot of speculation. And recently, the staff suggested that some sweep exams focused on compliance with the new marketing rule are coming down the pike following the compliance date, which was just in November 2022. So one thing that the exam staff has mentioned is that it plans to work closely with the Division of Investment Management to review and analyze the potential compliance issues putting careful thought into that before issuing these letters. And it's, as we've heard many times today, that they're not playing gotcha. It's to make sure that firms are aware of the new rule and that there's some good faith effort for new policies and procedures and revised marketing materials that are in compliance. So one of the areas of speculation where we could see a focus is under the substantiation requirement with the new marketing rule. The substantiation requirement requires advisors to have a reasonable basis for believing that they can substantiate all material statements of facts in their advertising and marketing materials upon demand by the SEC, should they be asked. More specifically, an intersection with forensic accounting and accountants in general would be the potential focus on valuations included in marketing materials and performance advertising and compliance with this substantiation requirement. So what does that mean? A fund advisor or an advisor has marketing materials that may refer to the advisor's success with certain investments when advertising a new or existing fund to potential investors. And that success is derived in part from what value has been placed on these investments. So the advisor needs to be prepared to substantiate any claims of success if asked by the SEC. Funds often engage third-party pricing services to provide this pricing information and to help eliminate conflicts of interest. So when using third-party pricing services to determine these fair values, funds need to remember their obligations to comply with GAAP and disclosure requirements, as we've heard at length today, maintain internal controls to prevent and detect material misstatements in their financial reporting, which would in turn show up in performance advertising and marketing materials, and always assess the effectiveness of internal control over financial reporting. The staff has indicated that registrants would be well served to consider certain questions when assessing and preparing marketing materials, such as, do we have sufficient information about values provided by third parties to know that they're complying with GAAP? Would we be in compliance with the substantiation requirement if asked for documentation? From an accounting perspective, some of the documentation to consider having would be, do you have support for the reasonableness of future cash flow projections that were provided from management of portfolio companies? If a fund's investing in high-risk private operating companies, does the fund have support for the revenue and expense assumptions that have been provided? Has the fund considered other considerations? Do these companies need capital contributions to achieve those revenue targets? Are there pending regulatory approvals that would be required? Things like that. Having the support, having the underlying documentation is key. Support for selected discount rates, have the third-party pricing services considered all of the risk factors of comparable market participants? How did they determine a market participant? Yeah. Does the fund understand the support and the sources for all this data and all the assumptions included in the valuations? So I think it still remains to be seen, but the substantiation requirement will be an area of focus that we could expect.
Maybe a 2024 topic.
Yes, next year.
Yes, we'll see.
Peter, on the new marketing rule, we here on this side of the aisle spent a lot of time sort of piecing together a lot of the requirements that are baked into that. And in my view, the rollout of that rule captures a lot of the prior enforcement actions relating to marketing material, like, for example, the F-squared line of cases. And some of the things that we've struggled with, my colleagues, are sort of a mishmash of different concepts like entanglement, adoption, net performance. So Jeremy, maybe if I could ask you, like in terms of from the commission or the enforcement's lens, is it at this point in time more a review of what firms have done to adopt the rule, or now more of a substantive view as to like what these firms are actually circulating?
Yeah, I mean, that's a tough question because I think it depends on, there's a broad range of things that could fall under both of those. And so from my perspective, I really think, if they're not implementing the rule in the way they should be, that's a problem. But it's going to be facts and circumstances on what kind of problem we're talking about there. And then whether they're violating the rule later as they're going along, different question, I know. But I just think it's too early for us to say. And from our perspective, the Division of Examinations is our eyes and ears. And they are going to give us feedback that will be helpful to us to understand kind of where the problems are. And I just don't think we're there yet. And Peter, before we jump to the next subject, I just wanted to follow up on something that Hardy said. He mentioned the idea that referrals might be coming sooner in the process because of that it's not even all the way through the complete deficiency letter process at times when enforcement shows up. And I can tell you that our goal in looking at whether to do something like that is really dependent on whether we think there's a real need to protect investors to do that. And there could be client assets at risk, there could be other problems that are serious enough where we're not going to sit around and wait for 3 months to see what the firm has to say in response to a litany of deficiencies when it's pretty clear that there's a real problem. And this is not, obviously most firms don't fall into this category with that kind of problem, but from our perspective, it's not as if we're trying to lurk in the background to jump in. It's more, okay, is there a real need for enforcement to participate? I can tell you from the number of cases that we're managing, our goal is not to pile on more cases on our caseload. We have plenty. It's more about, okay, is there a need to protect investors here? And the fact that remediation is being encouraged, I think is also a great thing. Maybe there is less of a need for us to jump in on a case where remediation has occurred and clients have gotten what they need to get. And so, to the extent that exam is starting to push that concept, I think that's a great thing for investors as well.
So in other words, something comes up in the middle of the exam and sort of like, hey, we might have an issue here, more of a live issue.
Right, that can happen, and at that point, does it make sense to wait several months for a response or not?
Okay, all right, well, that's great insight, thank you. So we started the discussion with non-scienter based charges. Now let's go all the way to the end of the spectrum, other end of the spectrum, and talk about individual liability, which is always an attention grabber. And again, at least from my seat, seems to be more of an issue these days in almost every case I've dealt with that's gone to resolution, there's been a discussion of individuals, even in some cases that just really have surprised me. So relevant to this discussion, and really as a way to kick off discussion on this topic, last summer, the SEC brought a case against an investment advisor and its principal and CCO, who were the same person, with the individual charges spurring a separate opinion from Commissioner Peirce regarding her view that the SEC really should go out there and adopt a clear framework for assessing CCO liability, similar to the New York City Bar framework, which has like a 6-factor test that they follow. So Jeremy, back to you on this one. Can you give us a little bit of insight about how the division is currently thinking about individual liability for CCOs? I mean, there's sort of a lot of buzzwords out there. There was like wholesale failures. Commissioner Peirce equated that to wildly inappropriate conduct as opposed to debatedly inappropriate conduct, which I got a little bit of a laugh out of. Where are we in this area of the law right now?
It's funny when you mentioned Commissioner Peirce's separate opinion. It reminded me that I'm supposed to give my disclaimer. So
It's too late. It's too late.
These are my views. These are my views, nobody else's, as you heard from all the other SEC folks today.
We need to get that just like up on the background here.
Okay, so let me start with, I think we view compliance personnel as basically the first line of defense against a problem. So I think in general, we view them as supporting what we're doing. We know that in the vast majority of cases, they're trying to do the right thing. We're not there to second guess business judgment. That said, it doesn't mean CCOs are immune from scrutiny. And there are some cases where the conduct vis-a-vis the CCO may actually point more toward firm liability. So for example, if they don't sufficiently resource compliance. If the firm isn't sufficiently providing the resources to compliance, that's not something where we're going to be viewing the compliance person as the problem. Or similarly, if they raise issues to the business people and the business people don't do anything about it, we're not seeing that as a compliance person problem. So I just wanted to, I know you've heard all that before, but it's helpful, I think, to remind folks that that's the general context in which we view compliance personnel. Then there are several places where it's pretty obvious that compliance personnel should be charged, and those are things like where they're actually involved with the fraud, or if they're covering up the fraud, or they've crossed some clearly established line. There's some examples: failing to produce required records that they know are required to produce and they don't, or putting false information in an ADV. Situations like that, fees going to the wrong party when they know they shouldn't be going to that party. Those kinds of situations also are pretty clear, okay? So now I think I've caught up to where you're talking about what about some other situation than all the situations I've just mentioned, and what does that mean? This standard has been phrased differently over the years. It's changed over time. Some prior officials may have called it a wholesale failure. And I know that there was criticism even at the time, even from within the commission, about that standard. And more recently, there has been this other formulation about failing to meaningfully implement compliance programs, policies, and procedures. I think all of that is helpful, but I think the reality is it's a facts and circumstances situation, and it requires a lot of judgment by the staff, and I think that's a good thing. I think some firms I think it's hard for compliance personnel because they view that as, well, there's not a bright line, so what do I do? But if whatever the formulation has been, whether it's the wholesale failure or the other standard I just identified, there has not been an avalanche of cases against CCOs because of that line, including a lot of judgment by the staff. So I think it has worked fairly well, despite that it makes people uneasy, because there has to be judgment in these kinds of cases. And just to address the case that Commissioner Peirce talked about, she, in the Hamilton Investment Council case, and I think the individual's name was Kirkpatrick, she was in support of the case. It was a separate opinion, but she was supporting the case. And she said that the CCO there, who was also principal of the firm, that charging him helped fulfill the SEC's regulatory goals. He had identified weaknesses in the compliance program, was in a position to address them, and didn't. She said that, and I'm quoting her now, although greater specificity may have been helpful for some purposes, I believe the order lays out a sound basis for concluding that this CCO's conduct here fell materially short. This particular individual knew that there had been outside activities engaged in by one of the investment advisor representatives and had failed to report it and never made changes to the policies and procedures that would have addressed the situation. It was a pretty kind of obvious situation. And as uncomfortable as it may be to not have a more sort of solid ground to stand on in this space, I do think that it has worked well. This is a situation where the person clearly fell short, and even Commissioner Peirce, who wrote a separate opinion to express her views on how the standards should be set up, agreed with the outcome. She did talk about the New York City Bar Association framework, the New York City Bar Association framework. I think that framework, much of it does align with the kind of guidance we've been talking about. It provides numerous factors, but at the end of the day, it's not all that different from what we're talking about, and I don't think it's in conflict with the formulations we've just talked about, whichever one you want to apply.
Yeah, look, I agree with you that if you really distill those 6 factors in that New York City Bar opinion or their guidance, it kind of gets to the point of these standards, wholesale failure, wildly inappropriate, whatever. But I sort of feel like more is better here in terms of actual clear rules. Maybe something like maybe Seaboard factors should go out and have a child. The CCO liability standard. I was hoping for some more laughs than that. Come on, it's like mid-afternoon lull here. Let's get it going, all right? Okay, so she did call out Commissioner Peirce about the outside business activities, that there were some vague references, at least in her mind, in the order to like the CCO having gotten reports or something like that, or communications relating to the OBAs, but it didn't quantify how many or how frequent or how clear it was. Anyway, I think this is probably an issue that will just continue to come up. Hardy, what's your perspective on this?
Yeah, so let me go to the broker-dealer side of the world, where we actually think about individual liability primarily in terms of failure to supervise. And FINRA issued a very interesting and important regulatory notice last year, 2210, basically saying that a compliance person doing a compliance role typically is not going to be deemed to be a supervisor and thus individually liable unless you trigger one of these factors, about, wholesale failure or active involvement. But an interesting point in that report is that's all true unless the supervisory procedures of the firm designate the CCO or someone in compliance as being responsible for a particular procedure. Then they become just a supervisor, and they do get charged if there's a failure in that supervision procedure. So going back to the investment advisor side of the world, the Investment Advisors Act has exactly the same failure to supervise concept that the broker-dealer provisions of the Exchange Act have. But the Commission and the Commission staff have kind of gone away from that since the compliance program rule went into effect. And so now in many, probably most of my investigations, there's a focus on, well, what did compliance do? And just having that investigation, I think, has an effect on compliance officers. I also think that there has come to be a belief that if there was a failure, then necessarily the compliance procedures must have been inadequate. And I don't think that's what the Commission actually intended when 20647 was adopted. And so, it is true that there aren't a lot of individual cases against CCOs. There are an awful lot of 20647 cases against firms, and I would respectfully suggest that the Commission maybe isn't thinking as hard about the difference between an actual substantive violation and a failure in a compliance program that justifies a 2064-7 charge in an order.
So, meaning like whether something actually, just because there was a failure doesn't actually mean that the compliance program wasn't reasonably implemented.
Or reasonably designed.
Is it reasonably designed, right?
Right.
Yeah. Okay, got it. So Jason, we were talking about this a little bit earlier about how CCOs in many firms are, just employees. They're not principals. They're not partners. They're salaried employees who are doing their best. What do you think about this topic? And also, how about extending past CCOs from individual liability just for business people?
Yeah, I mean, obviously, wearing the CCO hat, any action against the CCO has me and my colleagues on notice. I think, as a general matter, we all are very earnest in discharging our duties to implement a compliance environment in our respective firms that are designed to comply with the federal securities laws. If I just to zoom out a little bit, in our space, in the wealth management space, there's, let's say, $4 to 5 trillion in assets being managed, about 14,000 RIAs registered with the SEC. The average size of an RIA is about 500 million assets under management. And truth be told, most of the larger RIAs are just at the top. There's very few of them. So you think about the average RIA managing 500 million or less, really it's maybe a team of 5 people. And the CCO in that role is likely wearing many hats, including, in my experience, COO, CCO, and some other aspects of the firm that are not client-facing. So as we sort of crystallize that guidance that we can discern from these cases, I think it's helpful for anyone sitting in that role that's already under a lot of stress from the business side, working with very limited resources to implement a compliance program, to get visibility on how one should conduct himself or herself in the role of a chief compliance officer in order for there to be full compliance. So things like, so let's say the concurrence and the idea with the New York bar factors, there's the idea of implementing and discharging your duties in good faith, which to me imputes a negligence type standard. But then contrast that to the total failure aspects of that same view. There's a disconnect there because I think most folks sitting in my seat are discharging their duties in good faith. But is it truly where there is a absolute failure of our overall duties where there is potential liability?
Beth, what do you think about this from the CPA perspective? From your lens, are you seeing increased focus, individual liability for financial professionals in this space?
Yeah, I think I'm going to venture off of the CCO bit and just general individual liability. And you mentioned the most recent enforcement report. And in that report, the SEC stated that more than 2/3 of the standalone enforcement actions involved at least one individual defendant or respondent. So yes, there is an increase in these individual liability actions. And kind of tying it back into what I spoke about earlier with valuation and the substantiation requirements, documentation, and the like, the SEC had one, if not the largest, one of the largest valuation mismarket enforcement actions with Infinity Q and the former CIO, James Velasaris. And with that, Velasaris allegedly orchestrated this massive valuation fraud by overvaluing assets in two of Infinity Q's funds by more than $1 billion. And he did so by altering inputs into the third-party pricing system and manipulating the code of the third-party pricing system. So his inputs were inconsistent with Infinity Q's representations about independence of the process. There was lack of segregation of duties. He also additionally provided the SEC with false and misleading documentation when asked as part of their investigation. And this included removing text from investor materials, so tying back into these marketing materials. In an attempt to conceal the false statements, he deleted the text that was contradictory to what actually happened. He also created fake notes from valuation committee meetings and submitted these to the SEC as well. So ultimately, and very recently, he was sentenced to 15 years in prison and agreed to pay $22 million in forfeiture. So, that's a big deal. And I think we can expect to see more of the same.
Yeah, I mean, I'll just say from my perspective, some recent interactions where we got questions around the individuals involved. And to me, the import of the questions was, even though it was going to be a company-only settlement, the staff was looking for our assessment of the individual's conduct, at least in my mind, for some ammunition to use in the action memo that was going to get circulated internally, explaining why no individual charges were justified there. Whether that's policy or not, I won't put Jeremy on the spot, but it does seem to be more of a focus, and I guess we'll see how the continued activity goes. So I think we wanted to leave a little bit of time for closing thoughts from each of our panelists. And so, this panel, I was talking to Bruce last night, it's always shocking to me that it's almost late May at this point, and we're coming up on halfway through the year. And so maybe we'll start with Hardy, kind of working down the line here. What is one thing that you think conference attendees should keep in mind as we head towards, as I said, incredibly, the second half of 2023?
Well, so for the regulated industry space, I would just focus on the incredible number of rule proposals that are out there for regulated entities. And we had a panel earlier today about ESG, cyber, and SPAC rules, but there's T+1 trade settlement, there's equity market structure revision, there's new best execution proposals, there's custody rule proposals, IA vendor oversight proposals, an enormous number of proposals that firms may have to end up implementing all at the same time, and the proposals interact with each other. And I think the commission has bitten off an extremely ambitious agenda, and the potential for things to go badly when firms are trying to implement 15 or 20 different rule proposals at the same time is very large. And the commission does a lot of economic analysis on individual rule proposals. I think what a lot of people in the industry are saying is there needs to be some thought about how the different rule proposals all interact with each other, because, as I say, I mean, I don't want to be a Cassandra here, but I do see a little bit of a train wreck coming if firms have to do all of these things, if they all get adopted in the second half of 2023, before an election year in 2024.
Certainly has kept people penning comment letters quite busy over the last couple of years. Beth?
Yeah, I'll piggyback off of that, and just from an accounting perspective, I mean, constantly and proactively assessing internal control, how you can be responsive to the changes that are proposed. I mean, the direction things are going is pretty paved out right now. You can see where things are heading. Be proactive, collect the documentation, don't wait for an inquiry, be on the ready. And so being as proactive as you can to assess policies and procedures and internal controls in place.
Being ready for that SEC exam opening request. We're going to skip over Jeremy. We'll give you the last word. Jason?
Listen to the agency and the guidance. I think we are fortunate to be in a space where we are getting a lot of information about what the agency cares about. From in my perspective, you have exams, enforcement, and the Division of Investment Management, and someone who sits in the CCO role and has to craft an ever-changing compliance environment to react to the priorities of the SEC, as well as to attend to our client needs. You think about what are the headlines that we've all talked about here today, and the things that you can implement very quickly to eliminate some of the low-lying risk. Things like e-coms. I know, Peter, we're not supposed to talk about that, but that's forefront, as I know there's more coming. Custody rule, and understand, as Hardy mentioned, the raft of rules that are coming and soon to be implemented that will impact our way of doing business.
Jeremy?
Yeah, so I won't talk about coming rules, because that's sort of not my department, but I'll go back to where we started, which was talking about the off-channel communications cases, and Gurbir talked about those earlier today as well. And I guess the thing that comes to mind for me is that this is really a problem of industry not keeping up with technology and the nature of the business they're in. And I think that firms need to continue to focus on that, continue to focus on how things are being done today, which is ever-changing. And that I think we will continue to see cases that go after concerns where firms are not able to do that, where firms are not aware of what their personnel are out there doing and how they're communicating with each other. Or it may not be communications per se, there may be other areas like this where record-keeping requirements are not being met or other things like that. But in general, I think I just would ask folks to think about those issues and keep them front of mind, because I do think that they're important to us on the commission side of things, and we're continuing to see problems in that area.
I think that's all we had, and we're right at 4:10. Thank you, everyone.